Hello, I'm David Phillips, and I'm going to talk more about the mechanics of river movement and what happens to property rights when the river moves. As Tim said, the state got title to riverbeds in navigable riverbeds in 1889 when it joined the Union. At that point, the state owns both the surface and the minerals under the river. When it comes to navigable rivers like the Missouri River, which is what I'm going to talk about. Now, rivers are often used as the boundary line between properties. You've got property owners on one side, other property owners on the other side, and the state owns the riverbed in the middle. That is fine, except that rivers move constantly between different years, and even in the same year, they're higher and lower. So rivers then are difficult when you use them as a boundary for a property line. And interestingly, as the river moves over time, the state's interest moves with it. So the state owns the minerals under the river, even as the river moves. My first slide here shows how a typical river moves, just because of fluid dynamics and the shape and depth of riverbeds. One side of the river will be moving faster than the other side. Because of that, the one side is eroding faster than the other side, and the river meanders in the direction of the faster erosion. Some basic terminology when it comes to river movement, accretion and erosion. This is the typical process by which rivers move. The definitions under the case law are here, but essentially accretion is the buildup of land on one side of the river as the river is moving away from it. And erosion is the removal of land from the other side of the river as the river is overtaking it. Now there's a finite amount of land on Earth, so if the river moves and one person loses land, somebody else has to be gaining it and vice versa. And here you can see that process. We have accretion going in the one direction, giving land to the people on the bottom of that slide, and the erosion is taking land away from the people on the top of the slide. Now there's another type of river movement called avulsion. This is the common law definition of avulsion. It refers to the sudden inundation or sweeping away of land resulting from a sudden change in the course of a water body. There is a statutory avulsion, and a big difference between the two is that the statutory version does not have a suddenness requirement. But essentially what it means is that the river abandoned its former riverbed and formed a brand new channel. This is important because if there was an avulsive action, the people who lost their land when the water swept over it gain the former riverbed as indemnification for their loss, which can be a pretty huge windfall on occasion if there's a large meander that covers a lot of acres and an avulsive action causes the river to straighten out and it takes up less acreage. The people who've lost lesser acreage can get significant mineral rights under the large abandoned riverbed. But avulsion is not the typical case, and you would really need an expert to tell you if an avulsive action had happened. The typical process of river movement is erosion and accretion, and over time the river will eventually pinch off, as you can see here, and form oxbow lakes along. And if you go forward hundreds or thousands of years, this is what a mature river ultimately looks like. Now, I want to show you how the river movement affects individual property rights in a specific example. And this is an area I picked because it had the geological features that I wanted to tell you about. It's not something that we've done a title opinion on. And I'm using it as a sample spacing unit for you, but it's not a real spacing unit. Now, many of the wells that are being drilled now are being drilled into the Bakken Formation. And as such, they're usually a two-section spacing unit created by the North Dakota Industrial Commission. And they'll drill a horizontal well bore that'll go 2 miles out and cross the two-section unit. And those mineral interests in those two sections are pooled. And a title examiner would then be tasked with determining who owns the minerals in those two sections. Now, when the U.S. would grant a patent, the land description would probably come from the Government Land Office survey like this, or the GLO survey. The one that I'm using as an example here, this is from a survey that was done in 1896, and I put sort of a highlighting around the two sections that we're going to look at. Now, this is just zoomed in closer to the two sections we're going to use as a sample. And you can see the river is going through section 14 here. We've got section 13 and 14. There are riparian lots along the river. There's 8 of them. And the surveyor in this case, he labeled or she labeled the individual lots and put the acreage of those lots on there. There's also acreage for the total sections shown there. It's typically 640 acres if there's no non-riparian lots. In this case, it's showing section 14 as 457.7 acres. It's because the GLO surveys don't show the river acreage. So if you want to know the acreage of the river at the time, you subtract it from 640. Of course, in reality, most sections are not actually 640 acres. If you were to go out there with a modern surveyor with GPS and other technology, they'd probably come up with something a little bit different than what was used in 1896. Now here I've highlighted the riparian lots so you can get just sort of a better picture of it. We've got blue for the river and lots 1 through 8 shown. And at the time of patent, these lots might have been patented separately, or there might be deeds in the land record over time where these are later owned by various mineral and surface owners. The title examiner would try to determine who owns them today. Now, as the river moves over time, the size of these individual lots are either going to get enlarge or shrink. And so we want to know how large they are later in time because we want to know how much to allocate to each individual tract. So if we have a spacing unit that's 1,280 acres like this, we want to know how much each of these lots makes up out of the whole. So if 1,280 is 100%, what percent is lot 1 here? Now that matters because it will affect the breakdown of mineral ownership. So if we have a producing well on this unit, we need to know how much we need to pay the owners of lot 1 when the proceeds of production come in. It also affects, if there are different working interest owners, how much the working interest owners have to pay if they want to participate in the cost of the well. And there's a lot of different sources you can look at to see how the river has changed over time. This is a 1914 standard atlas of Williams County that we just had in our office. And I pulled it up here. You can see in this case the river is still largely vertical, and it looks like it's still entirely within section 14. It doesn't look like it's changed much from 1896 to 1914. But this was stitched together digitally. It's taken from 2 1952 aerial photos done by the U.S. Air Force. And I got these from the U.S. Geological Survey website. The web address is on there, and then there's a URL on all the images that are in my presentation here that you can use to find the source if you're doing research on this on your own. This is actually from 2 photographs. If you were doing this work yourself, you might have to print off the different photographs, and you'll find that a lot of surveys and aerial shots, they're at weird angles, and you've got to print them out, cut them up, fold them, tape them, and try to make it look like it works. If we zoom in, this is a closer shot. It's the same image, but closer on our 2 sections. And we can overlay the GLO survey, and you can see now how much the river has changed from 1896 to 1952. In this case, the river has washed completely over lots 1, 4, 5, and 8, and those lots have reemerged on the other side. Now those lots are now gone. They've been completely eroded, and that land is now accretion to the other lots, which would be 2, 3, 6, and 7. 4, 3, 6, and 7. Now the only way that you could ever get back lots 1, 4, 5, and 8 is if the river came back the other way, washed back over them, and they reemerged on the same side of the river that they started on. Now, this is the ordinary high watermark survey that Tim was talking about, and this is prepared by Bartlett and West, Inc. And this is used by the state to determine the location of the ordinary high watermark. The website for this is on the slide. It's a very good resource. It has photos and maps. It has spreadsheets of the acres above and below the ordinary high watermark. And the survey methods that were used are also on the website. So it's a good resource. It's the North Dakota Department of Trust Lands website. Now the state of North Dakota owns under the riverbed of the Missouri River, which is what we're looking at, But where is that line? Where does the river end and the land begin? The state claims it's out to the ordinary high water mark. That's what they've put in red on this. That may or may not be true. It's an open legal question. Even if it is true and the state does own out to the ordinary high water mark, where the ordinary high water mark is in a particular spacing unit is not necessarily known. This is just what the state is claiming, and a fact finder could find something different in a particular case. Now we're zoomed in on our two sections. It's the same photo, it's just zoomed in. And here you can see it's shaded in blue what the state is claiming, and you can see there's a significant difference between what the state is claiming and what looks to be river, which is really the lighter shaded area. That to me looks like the water. The state's claiming a significantly larger amount than you might think if you just were to look at the aerial photograph. This is the same image, except now we've removed the underlying aerial photograph. This is also on the Department of Trust Lands website. This shows the acres as determined in the ordinary high water marks survey above and below the ordinary high water mark per quarter section. And you'll notice that these actually add up to something other than 640. It's kind of what I was saying before. A modern survey technique is different than what was used at the time of the GLO. And this matters because if we say that the total unit is larger or smaller, if the state is claiming the river is a certain number of acres, growing or shrinking the size of the total unit affects what percentage of the unit is made up by river. But it's our understanding that the state will accept the GLO acreage for the size of the total unit, but is still claiming the acreage under the river that's shown on this ordinary high watermark survey. This is the same image, and I've overlaid again the GLO numbers and location of the river. But now that it's changed, we need to redraw the lines so that we can see where the lots ended up, so we can figure out how many acres are in each lot. Now it's tempting to draw them out like this, which is just to bring them straight across. And sometimes if you're doing title work, this might be what you have to do, because if you don't have a surveyor, this is all you might be able to do. And then you have to try to determine what the acreage is of each of these. And sometimes you have to use some deductive reasoning if you know the acreage of a quarter section and you know what some of the lands are within there, you might be able to deduce what the remaining lands are. That's sometimes possible and sometimes it's not. Sometimes we've used various software suites to try to determine it too and be sort of amateur surveyors, but if we're doing that, it's just going to be an estimate. A client would have to be advised to get a survey. The problem, of course, with a survey is that if your client gets a survey, another party may get a different survey and it becomes a battle of experts. So typically, if you had individual parties, they could stipulate to the number of acres or stipulate to their ownership in the unit and sign a division order. That is more difficult if the U.S. owns an interest. The U.S. does own mineral interests in certain parts of the river, riparian to the river, and they're significantly more difficult to deal with. The federal government will only accept the acres that are shown on the last approved survey, which in some cases is the GLO. So the federal government is often basing its numbers on something that's clearly not reality. It's based on something that's very old, and to get them to change is difficult. You need to have a more recent approved survey, but there's a lot of hurdles to jump through and it can take a long time, and by the time you do get a new approved survey, you might already have an existing well on the property, and the parties might have entered into their own stipulations and agreements that can get very complicated. So that a lot of caution should be used whenever the U.S. owns an interest in a spacing unit, because there are many more regulations and statutes that you've got to comply with prior to drilling. Now, as I said, it's tempting to draw the lines like that, but it's not actually correct. This is a cite from the North Dakota Supreme Court, and it's essentially saying that you don't draw the line straight out to the river. You maintain the proportionate share of the shoreline for the different lots. So if lot number 1 had 10% of the shoreline and lot number 3 had 30% of the shoreline, you'd have to maintain that over time. You wouldn't just maintain the same lines. You have to, what matters is the shore. And the lines don't respect section lines, they don't respect quarter section lines or anything like that. So if you were to have an actual survey done to figure out the way the lots are today, it wouldn't look like that. It would look something like this. This is just my effort here. This is not what an actual surveyor would do. I just wanted to show you the principle of how this works. Something very important that you'll notice about this slide is that in this case, when the lines bend, they don't respect section lines, and we have lot 2 from section 23 that's now come up into our spacing unit. Now, if you were doing a title opinion and you only received the records for sections 13 and 14, you wouldn't know who owns that little, so I've hatched off this sort of triangular area there where lot 2 of section 23 comes into our 2 sections. You wouldn't know who owns that, and so you've got an unknown tract with, it's potentially unleased, and potentially a greater danger there is that they might be owned by the United States. And so if you're unaware of that, you could drill through federal minerals and without a permit, which wouldn't be a good thing. So you would definitely want to know this in advance of drilling. Now sometimes if you're doing a title opinion, you might not have the benefit of something like this done by an actual surveyor, but you can often figure out what the risk is, which lands adjacent to ours are likely to come into ours. So a client can be properly advised and probably get land records for section 23. One thing about these, the land records is that if somebody issued a deed for their interest in lot 2 of section 23, it would probably describe it just that way, lot 2 of section 23. If that was then recorded in the county, it would be indexed only against section 23. So if you failed to get land records for 23, if you only got 13 and 14, then you'd be totally unaware of this altogether. Based on what I've showed you, it's very important to know where the river was throughout history, to know where it is now, to know where the property rights are today. You have to look at where they were all the way back to the time of the GLO. But the history of it is important for another reason, and that's, if you went out there today in an airplane and flew over it, our 2 sections actually look like this, which is nothing like what we've looked at so far. It's because all of it is under Lake Sakakawea, almost. There's a portion there of section 13 that's not. But this has all been inundated with water after the creation of the Garrison Dam in the early 1950s. Now the state has taken the position that it owns out to the ordinary high water mark prior to inundation with water from Lake Sakakawea. So we're naturally looking at historical images and historical surveys to determine where the ownership is today, which I think is fairly interesting. I mean, pretty good time, and I think Diana's going to tell you some things about ownership in tribal lands. Thank you.